Okay, good morning, everybody. Can everybody hear me? Okay, the microphone seems to be working fine. Okay. All right, thank you, everybody, for coming today. Good morning, and welcome to the Veterans Access Seminar. This is a showcase of the court system and the efforts of the court system to fulfill its mandate to ensure the just resolution of disputes, and also of the people, programs, and services available to assist veterans and the community. This event is sponsored by the Essex Vicinage Advisory Committee on Minority Concerns, under the leadership of the Honorable Verna Leith, that is charged with making recommendations to ensure equal access to the courts for minorities and all court users. The goal of this forum is to share information and to listen to any concerns you may have about accessing the courts as consumers. Just a brief word, please, if you have cell phones, if you could just silence them. The restrooms are outside to the right and to the left. And my name is Andrew Kafel. I'm a probation officer, and I'm the chair of the Veterans Access Subcommittee of the Advisory Committee on Minority Concerns. And I'm pleased and honored today to meet with veterans and persons interested in their welfare. I would especially like to thank the Township of Montclair for hosting this forum, and to Dr. Kate York and Richard Gearhart for facilitating our use of this space. And I'd also like to thank Clarence Jackson, who is a veteran, and he is with the Montclair Senior Citizen Advisory Committee, and he also helped us to access this space today. We're going to have a special focus on the Veterans Court, which was recently started there was a law that was passed last year that implemented Veterans Courts in New Jersey, and one of our speakers will be speaking towards the Veterans Court. The staff of the Essex Superior and Municipal Courts are conscious of the unique needs of veterans and the costs borne by veterans and their families due to military service. Many court staff are themselves veterans. The Essex Court has established the Veterans Access Program, whereby any staff member working with a person who identifies him or herself as having a military history and is in need of additional services can refer that person to the Veterans Health Administration for available services. Over 1,200 referrals have been made to the VA in the past 7 years in Essex County. I'd also like to mention that we are recording the event today, and it will be live streamed. We'll give information how you can access that. You can watch it in the future, and people actually could be watching it right now. So we have with us a panel of distinguished experts from the Superior Court and the legal profession to talk about their respective programs and to respond to any questions at the end of their presentations. To start, I would like to introduce the Honorable Theodore Stevens. Judge Stevens grew up in East Orange, New Jersey. He attended East Orange High School. He was a football scholar athlete and was inducted into the National Football Foundation Hall of Fame. He attended Seton Hall Law School. He was awarded the Monsignor Thomas Fahey Award for Student Activism. While he was at Seton Hall, he served as a judicial intern for the Honorable Irvin B. Booker at the Newark Municipal Court. Following law school, Judge Stevens completed a judicial clerkship with the New Jersey Superior Court Judge Paul T. Murphy. He became a corporation counsel for the city of East Orange. In 1994, he was appointed a judge of the East Orange Municipal Court. He was thereafter appointed to the bench of the Orange Township Municipal Court and was sat through 2011. In 2002, Judge Stevens served as president of the Essex County Municipal Judges Association. In 2011, Judge Stevens was elected the Essex County surrogate, which is his current position. He'll speak about the role of the surrogate. But the surrogate presides over non-controversial estate matters in Essex County. He was the immediate past president of the statewide surrogate section of the Constitutional Officers Association of New Jersey. Judge Stevens is a past Grand Polaris International President of the Iota Phi Theta fraternity, the fifth largest predominantly African American fraternity. And one of the accomplishments of the fraternity was the rejection of hazing in 1991 and the adoption of a membership intake program for the fraternity. And Judge Stevens also serves as an adjunct professor at Fairleigh Dickinson University and Essex County College, and he is a member of the National Bar Association, the Garden State Bar Association, and the Essex County Bar Association. He is the past chairman and longtime member of the East Orange YMCA Board of Managers. We're pleased and honored to have Judge Stevens. Please welcome Judge Stevens.
If we can do it from here, I like that. Good morning. And thank you for that way too long introduction, Andrew. I appreciate that. He read that just like I wrote it. It's perfect. I love it. How's everybody today on this rainy day? All right. Good. We're here to, in this informal setting, if you will, but to give you some very important information. As Andrew indicated, that this is a panel of expert individuals, so that I hope that you don't take the informality as anything less than what it is, because there's a lot of great information that is going to be handed out today. As always in these types of seminars, it's difficult to take in everything that you may hear at one time. So I'm sure that most of us will be available for communication either today or on another occasion. I am the surrogate, and I guess that's enough to say everybody knows, just by virtue of that, you know exactly what I do, right? No, nobody knows what the surrogate does. So don't feel bad at all. As a surrogate, I'm a judge in the state of New Jersey for Essex County. The surrogate, there's one surrogate in every county, and the surrogate is the only elected judge in the state of New Jersey. I served for a 5-year term, and this is the second year of my second term. Prior to that, I was a municipal court judge for a number of years, sitting in a bunch of towns in East Orange. But as surrogate, I have a court of very limited jurisdiction. I handle primarily the probate of wills, trusts, and estates, and also handle several other functions which we'll talk about as well. Now, I handed out two aspects. One is the presentation for today is a yellow sheet, and the other one is the more general document which we hand out to everyone that explains in much more detail about the surrogate's court and gives you some tips that I'll talk about without necessarily referring to the document, but that one is the one I commend to you for just general reading and understanding about what the court does. So let's start with our presentation, because it's going to be a quick turnaround. The first, after the introductory page, there's a very strange picture there of what purports to be a caveman family. Now, why that's there is to explain generally just what about the how the law of estates and passing your inheritance to someone else occurred. In the old days, of course, in the days of caveman, that you would be with your tribe, and basically you'd be walking around, and one day you would drop dead. In which case, those who were with your tribe would gather your belongings, pick up your club, your loincloth, or whatever, and they would take it and walk away, and they'd leave you there probably. Okay, that's how your estate got passed from one person to the other in those days. Let's just think about it. It had to be. We weren't there, but it had to be like that. Now, as time evolved, so did the succession process. But the tribal nature of it in terms of who gets your assets, or I affectionately call your stuff, would go to the people who are related to you most closely. Blood relationships is based on the law of consanguinity. Next of kin. If you're from West Virginia, your kinfolk. Same thing. So that without a document called a will, the only people who stand a chance to inherit your items would be those related to you by blood. Ergo, the development of a document called a will. Now, the will and the surrogate's court itself goes back all the way to the beginning of New Jersey and comes directly from England. I am a constitutional officer as opposed to other judges who are creations of statutes, which happened after the Constitution, obviously. And so, by virtue of that, it has been ingrained in the system forever, using the same concept that I just spoke about. Eventually coming over, and the governors who was appointed by the King of England in the 1700s. Primary functions, as I talked about, were establishment of the estates with or without wills or trusts, which I'll talk about a little bit more in a second. The administration of adoption complaints, which we also deal with. Maintaining a repository of records. We have the records going back almost forever of any will or estate that was probated in New Jersey. And I also serve as the deputy clerk to the Superior Court probate part for those cases which I cannot handle in the surrogate's court. I also am sitting on minors' trust funds because minors cannot own property in New Jersey. What's a minor? Anyone less than 18 years old. So that I sit on about $36 million worth of assets right now that will go to individuals once they become 18. However, that's not necessarily a good thing. One is good in that the assets will be preserved for them until they're 18. But who here thinks it's a good idea to give a bunch of money to an 18-year-old? Probably not a good idea, but nonetheless, that's what happens every day. I also perform marriages, and I also administer guardianship complaints for the Superior Court, which I'll talk about in a little bit more detail. Now, we're going to talk about veterans especially, but just with regard to wills, just to finish up that topic, because I don't have a very limited time. Everyone should have a will. And a will is not necessarily just for individuals with substantial assets, but it's anyone who wants to leave their stuff to someone who is other than a blood relative, for instance. If you want to leave it to a church or another nonprofit, the only way to do that is if you designate that in advance. A will must be prepared in accordance with the law. There are very few requirements. Basically, that it must be in writing. It must be witnessed by two individuals and signed by the testator, you, the person who owns the will. That's basically it. I think there should be an additional requirement in the law, but it is a provision that it also be notarized, and that makes something what's called self-proved. Because without that, then witnesses must be produced at the time that the will is actually probated. But if the notary notarized everybody's signature at the time that the will was executed, then we don't need to provide those witnesses. And that can be beneficial because oftentimes these wills are not probated until 20, 30 years after they're actually executed. It could be difficult to find individuals who are witnesses. So having it self-proved at that time is a real benefit and can get the will provided and can slide through instantly without the witnesses. Now, there are a few exceptions and benefits. Certainly, there are not enough benefits for those who are veterans. And first, I should have started off by saying those who are veterans here, thank you for your service to the country. And that's first and foremost. So that we really can't do enough, I think, for veterans in terms of making your lives easier once that you've provided that service to the country. And so we're looking for additional ways to do that. In preparing for this, I was actually surprised that there are a few benefits that the surrogate's court does provide that we don't actually take advantage of or administer on a regular basis because a lot of few individuals come in and ask for some of the special provisions which the law provides with regard to veterans. First, with regard to wills, I said that the will must be witnessed by individuals. If in fact, adults obviously, and if in fact though someone within 2 years from being discharged and they do pass away, a veteran passes away, that we don't need to provide or find the witnesses for those individuals. So there is a 2-year period that if that, I guess assuming that perhaps a malady from serving in the military may have contributed to that passing, I don't know, but it could be. But they have that 2-year window that if the veteran does pass away, we do not need to look for those witnesses. And as I said, if it's not a self-proving will, then that can be a real benefit because that holds up the administration of the will without having, in many cases, if a witness can't be found. So that's a special provision that is only available to veterans as far as I can tell from looking at the statutes. Also, there is a benefit that veterans get with regard to transfer of real estate. Now, in New Jersey, when property is transferred, there's usually something called a realty transfer fee. That's a statutorily provided fee, and it is based on the value of the property. The fee will vary. And there is an exclusion of that fee for veterans that's transferring property as well. So for those of you who are involved in the sale or purchase of real estate, you need to provide that, or at least inquire of your attorney whether or not you're getting the benefit of that exclusion, because that can save you several $1,000s with the transfer of property. That can be a real benefit as well. There are also some special provisions with regard to guardianships. I talked about that generally in terms of what we do in the surrogates court. And a guardianship, that is a court proceeding. That is one where there is a verified complaint and order to show cause, 2 very particular documents that must be filed. They have to be prepared properly, first of all, and there usually requires an attorney to do that. And they are filed with the surrogates court, and we serve as the deputy clerk to the superior court probate part. A guardianship essentially is a action for someone to take over your life, a person's running your affairs, if you will. And it's a very serious matter. That's why it goes to the superior court and can't be done in a summary fashion, because there are a lot of requirements and there are a lot of protections which the person who is called an alleged incompetent at that point is entitled to, and the court requires that those protections are proven on the record for the benefit of the individual. Now, this comes into play particularly for, and by the way, this is a burgeoning area in the law. It's growing. We're getting more and more guardianships. There's a lot of new law that's come out as a result of it. The surrogates are interacting with the administrative office of the courts on a regular basis with regard to that. Let me just say, with regard to that, though, I told you need a will. You should probably, as part of your estate plan, also have something called a power of attorney. Now, that is a document that's prepared and where you are indicating what individual you want to help with your affairs under certain circumstances. That also can be prepared in an attorney's office, and people say it could be cost $1,000, maybe a little more. Oh my God, I don't want to pay that kind of money. But listen, this is the benefit. With that power of attorney, you are picking the individual who you want to help with your affairs. You make that decision because you're the person who's drawing up that document. It becomes effective almost immediately. It's sitting in a drawer, and it either springs and becomes effective, or it's effective at the time that you draw it up, and it's there to be used. Now, one of the difficulties of a guardianship action with that verified complaint order to show cause is that that's a court case. This is Essex County. That means that you're going to file that complaint, you're going to get in line in the busiest court in the state of New Jersey, and it'll be a process. The judge will provide or appoint an attorney for the alleged incompetent person, the veteran perhaps in this case. That, of course, the other attorney for the person who wants to be the guardian, who may or may not have been the veteran's choice, but somebody who's making that application, good faith in most cases, but nonetheless may not have been your first choice. And then that case proceeds. Your other relatives get notified. They may say, wait a minute. Why should A be the guardian? I'm a better guardian. So they get their attorney and they inject themselves into the case. You see how this can get out of control. And it certainly would be very many months and certainly many thousands of dollars that generally gets paid out of the alleged incompetence estate, by the way. All of that can be avoided in many cases by having that power of attorney that sits there where, again, you've chosen the person to act on your behalf. So, but with regard to that, one of the big areas that guardianships can be required if you don't have that power of attorney would be for a federal payor, someone who's providing benefits to an ex-military person, to a veteran. So that application would be made also through the surrogate's court. There are certain requirements that would apply without going into detail. Essentially, that the payor, the federal payor, must be made advise who the guardian is, and then there must be a mandatory accounting, which is really the same kind of in all guardianships, which is a regular accounting to the court and to the federal entity who's the payor about what the guardian's doing with your assets. Because even though you can appoint someone or have someone appointed to handle the assets for you, they can't do it without some interaction with the court, because we want to make sure that the person is doing the right thing with the, at that point, the alleged, not the alleged incompetent, but the adjudicated incompetence assets. So it's really important for everyone to think about that, having that power of attorney. Otherwise, you really are subjecting yourself to a little bit more arduous process of dealing with the surrogate's court and the probate court with regard to managing assets. There's also provision in the statute that deals with management of assets that come from non-federal sources, but essentially it's the same process where that guardianship application must be filed. The real benefit is, I think, through the statute is that the fees that would be associated with that, which can amass about $350 for filing of the complaint and the order to show cause in most cases, would be waived for veterans. So that it's important that for those of you, if you have friends who have passed away who are veterans, that those who are seeking to administer their estate either with or without a will, that it's made known to the surrogate's court that the person is a veteran or was a veteran, and so we can get their fees waived with regard to that. And of course, with the guardianship application, that same information must be given to the court. So, the last page there has a picture of a gentleman with pulling his pockets out that are empty, probably a relative of mine. He has no money. And just indicating that really it's not, having the estate plan that I talked about is not just for the wealthy individuals. It's for anyone who cares about what happens to their stuff, because my guess is that you worked hard for your stuff. Is that the case? And that you really care what happens to it after the fact. So that if you do, that you really need to have the estate plan put together, that will, the power of attorney I talked to, and also a living will, which is a healthcare document that needs to be put together. And those three documents make a reasonable estate plan. There really is no good reason not to have that, but the reasons I hear most often is, one, I'm too young and healthy to need this estate plan. But there's an old commercial about an insurance company, and their logo or their slogan was, life comes at you fast. And we know that, everybody knows that, for individuals who are fine one moment and then not so fine the next. And so we really can't, don't know when our time is coming, so we should do that once we amass anything that we're interested in passing on to someone else. And if we care about who is in charge of the estate, because those of you who have children who might be the ones you figure are going to be the ones in charge of your estate to help along, you know the ones that should be in charge of the estate, and you know the ones that should be kept as far away from the money as possible. Having the will is the opportunity for you to make that decision, because sometimes for families it's difficult to do that after the fact. Secondly, my spouse or children will get anything anyway. That may or may not be the case. We've got a lot of blended families in this day and age, so that makes it a little more difficult. Perhaps the third most interesting reason I've heard is, I plan to live forever. Okay, good luck with that one. We'll see. And the last one, which I think is the main reason why people don't have an estate plan, is, I like it when my family fights. That must be the reason. So that was just a quick snippet in terms of some information I think you need to know about. I hope that you find some of that interesting. I commend this document to you for your reading, because it's got more in-depth information. And if, in fact, you need more information, you can contact. My contact information is in that manual as well. Thank you so much.
thank you, Judge Stevens, for enlightening us about the sometimes mysterious operations of the court. That's why we're here, is to shine a light on what the functions and roles of the divisions and the people in the court are. I'd like to call your attention to the Ombudsman's Office of the Superior Court, that if you have any questions, please look them up. There's information on the back table. They can answer questions and steer you in the right direction. The goal of the Advisory Committee on Minority Concerns is to ensure access, so for everybody, for minorities, for everybody to be able to access justice, to resolve disputes, and to so that we can manage our lives and move on. Thank you, Judge Stevens.
Pleasure.
I just want to say a word that we invited Dan OBrien from the Office of the Public Defender. He's a staff attorney with the Division of Mental Health Advocacy. He provides representation for service-related mental health issues. Unfortunately, he was unable to be here today, but I did want to recognize him and his role. Our next speaker is Gwen Williams, and Gwen also has a multitude of achievements. I'd like to try to summarize. Gwen Williams is the Deputy Chief Assistant Prosecutor. She was recently promoted to the Executive Assistant Prosecutor, and her responsibilities include staffing issues and hiring and collective bargaining for the prosecutor's office. In her role as the Deputy Chief Assistant Prosecutor, she is in charge of the Victim Witness Program, the Juvenile Trial Unit, and I've worked with Gwen for many years in the Juvenile Unit as a probation officer. The Community Justice Unit, the Drug Court Unit, and the Mental Health Unit. Also, she has been a part of the Greater Newark Safe Cities Initiative, the Gun Strategy Program, the Trigger Lock Program, the Weed and Seed Program, the Fugitive Safe Surrender, the World Against Violence Youth Conference, the Summer Youth Internship Program, Speakers Bureau. She meets with community residents and leaders to discuss pertinent quality of life issues regarding their various neighborhoods. As the director of the Drug Court Unit, she helps defendants who are seeking admittance into the drug rehabilitation program. And the drug court is a program within the court for people who have been charged, but is a way of diverting people to emphasize rehabilitation. Yes, and also she works with the mental health unit. The goal is to help defendants become positive members of the community by addressing their addictions, their drug addictions, or their mental health conditions. Ms. Williams is an active member of the Garden State Bar Association and served as its president in 2009 and 2010. She is an active member of the Association of Black Women Lawyers of New Jersey. She was a founding member of the Honorable Ann E. Thompson Inn of Court. She is an active member of the National Black Prosecutors Association and serving as its national vice president of organization from 2002 to 2005. She graduated from Antioch School of Law in Washington, D.C., and she received a BA in political science from Rutgers University, Newark. Please welcome Gwen Williams.
Good morning, everyone. I just want to say to our veterans who are in this particular room, just like Mr. Stevens did, I would like to take the time, first of all, to thank you for your service. And I'm here to talk to you about the Veterans Court. The Veterans Court is probably the youngest court in the judiciary in that it was created and became effective on December the 1st, 2017. And exactly what does the Veterans Court do? The Veterans Court is that any person who is a veteran who has been other than dishonorably discharged from the service are looked at in terms of if they are have involvement with the criminal system, that what can we do to help them not be incarcerated. So what happens is that at the point a person is arrested, one of the questions that a law enforcement official will ask that person is whether or not they are a veteran. And if they are a veteran, that information is filtered to law enforcement, and we look at the charges and we determine whether or not the veteran would be eligible for a diversionary program. So what does diversionary mean? That means basically that you have some type of probationary requirements that you have to complete instead of getting a record for that particular arrest. So, and what the law states is that it has to be either a 4th degree or 3rd degree offense in order for the veteran to qualify. It cannot be an offense that is of a violent nature. That means we have 3rd degree aggravated assaults. If it is an aggravated assault, the veteran is not eligible for the diversionary program, the Veterans Diversionary Program. And also we look at the criminal history of the veteran. And if the veteran has been convicted of a 1st or 2nd degree offense, they would not be eligible for the program. However, we have a former Essex County prosecutor by the name of Carolyn Murray, who about 5 years ago, when she was the Essex County prosecutor, decided to initiate a mental health program here in Essex County. And what we have done in that mental health program is that if the person coming before us for either being dishonorably discharged and therefore cannot qualify for the Veterans Program, or if their prior criminal history record does not allow them to be a part of the Veterans Program, we will look to see if they can become a part of our regular mental health program. And how that is comprised of, it's a team. First, the prosecutor looks to see if the veteran is legally acceptable to become a part of the program. And we look at all those things we just told you. And then secondly, what happens is that the veteran is interviewed by what we have as a mental health substance abuse evaluator, who based on their knowledge will look and interview that particular veteran and determine whether or not they are clinically acceptable. And we also have a clinician. We work in partnership with the Essex County Hospital as well as the courts, and all those cases in the mental health program as well as the Veterans Program are heard before the Honorable Verna Lee. Now, so when we look at everything as a whole, we try to help the veteran go to one of those two programs, depending upon the charges. Sometimes, once we hear at the very arrest level that the veteran, that the person is a veteran, they may qualify not even to be a part of the court system. What would happen is the law enforcement officer would contact our office, and we would determine something similar to a station house adjustment, that maybe they should not be a part of the court system, and we can have a program set up where they have to do certain probationary things in order to have that record dismissed. So we do work it that way as well. But one of the key elements is that it's not a program where a person is arrested and the prosecutor's office says that, okay, you're a vet, now you're a part of this program. All people who are arrested are represented by legal counsel, and upon conversation with their attorney, they apply for our mental health or our veterans program. So the impetus is on the person who has been arrested, the vet who has been arrested, through his attorney to actually apply for both programs, except at the point of arrest where we're going to divert you and not even make you a part of the criminal justice process. So it's normally a year to 2 years probationary period, depending upon what the offense was, as well as depending upon what the clinician states that the veteran needs in order to help them become well again. They assist with getting medications, as well as they assist with certain programs. We have people who help to get housing if that's needed. We have been in contact with various veterans associations who also has contacts that will meet with the veteran and help the veteran be assisted in getting certain things. Now, I said that the veteran cannot be, in order to be a part of the program, have to be other than dishonorably discharged. We have met with a veterans association that has stated that in the event that we have a veteran who was dishonorably discharged, they would meet with that particular veteran and they would help that veteran appeal the dishonorable discharge. And in some cases, those dishonorable discharges have been reversed. They do not guarantee that all of them will be, but it is an assistance that the veteran would not have. And that's basically a representative from the Vet Center who will help do that. And I believe Guy Vanderpool is in the audience. Mr. Vanderpool, if you would stand up. He's the representative from the Vet Center, and in his job, that's one of the things that he does in order to assist veterans. So that's basically the Veterans Program in a nutshell. We have had success with people who are veterans who successfully come through the program. We have people who help them try to get housing if housing is an issue. We have people to help them to try to get jobs if jobs is an issue as well. But we're looking at the vet now differently than what we normally would look at any person that presents with a mental health illness. It's brand new. It's less than 6 months old for the veteran side of the mental health program, but our mental health program that we have, our regular mental health program in the county, is approximately 5 years old. So we do have people in place to help, and we do assist when needed. And that's basically it in a nutshell.
Thank you, Ms. Williams. I would be remiss if I didn't recognize some people who are with us in the audience today. Mark Coriel is with the Veterans Administration. He is the Veterans Justice Coordinator. Okay. Also, Colin Porter is with the Superior Court. He is the Equal Employment Opportunity and Affirmative Action Representative for the Superior Court. And Dr. Yolanda Marlowe is with us. She is the chair of the statewide Minority Concerns Committee. Yes, thank you for coming today. Our next speaker is Rosa Neal, and she is a staff attorney with the Volunteer Lawyers for Justice. She oversees the PSE&G Veterans Clinic and the Veterans Legal Wellness Clinic. Prior to joining the Volunteer Lawyers for Justice, Rosa was a corporate associate at Davis Polk and Wardwell and Covington and Burling in New York City. Please welcome Rosa Neal, and she will be, she provided us with a PowerPoint, so she'll be using PowerPoint.
Thank you so much. Okay. Thank you, everybody. I'm happy to be here. I gave a short bio. I guess I should have given more details to Andrew.
Go right ahead. I'm sure that you can say.
So thank you all for coming on this rainy day. I'm excited to tell you more about my organization, which is Volunteer Lawyers for Justice, and tell you more about what we do for veterans. So we are a nonprofit organization. We're based in Newark. So our mission is to improve the lives of economically disadvantaged adults, children, and families in New Jersey by empowering them with tools, advice, and pro bono representation. That means legal services at no cost, with the goal of securing fair and equal treatment in our legal system. So we all know how expensive lawyers can get, and every service that we offer is free to our clients. There are certain criteria that you have to meet. For most of our programs, there are income eligibility criteria, sometimes residential requirements. But for the, for one of our veterans legal clinics that I'll tell you about, anybody who is a veteran can come in. So, if you can forward me one up. Thank you, Andrew. Okay, so this is an overview of the different programs that VLJ offers. So we have programs that are open to anyone, even clients who are not veterans, such as our Children's Representation Program. We have a divorce clinic. We deal with human trafficking. We have a bankruptcy program. We have consumer law for issues of credit and getting harassed by creditors. We have a landlord-tenant clinic. We've also responded to disasters in the past, to hurricanes. And one of our core values, as you can see here, is advocating for veterans. And we have a veterans legal program dedicated to do that. So that started, VLJ put that in place together with PSEG Corporation. And the second of the two clinics that are listed there was actually the first one, the Veterans Legal Clinic, which is held at PSEG, and it's staffed by attorneys from that corporation, from in-house. And they do that together with two partner law firms that are, one of the major law firms in Newark, McCarter and English and Gibbons. And then the second of the clinics, which is listed first, came second, and that's our Veterans Legal Wellness Clinic. And that came together with the VA, with Mark Corielli, who's here. So he expressed the need to have a legal clinic right at the East Orange VA. And so together with him, we put that together, and we have that there. So I'm going to tell you more details about each of these clinics. So the Veterans Legal Wellness Clinic, I'm going to talk about this one first because it's really the way we envision veterans coming through our programs. This is really the first step. So what we want this clinic to be is to be a holistic checkup, like when you go to a doctor to get your annual checkup, but this is a legal checkup, right? So the idea is that a client who's a veteran would come in and perhaps report that they're having a specific issue. For example, they believe they need to, declare bankruptcy because they're having trouble paying their bills. So what we would do at this meeting is we would listen to that issue and evaluate that issue. It's a meeting with attorneys. But also the attorneys would go through a questionnaire and ask more questions to see if there are other issues that are impacting that. So for example, if the veteran client should be receiving child support, but they're not receiving child support, maybe the first step should be to get that person child support benefits, and then they wouldn't be in a position to have to declare the bankruptcy, right? So the idea of the clinic is to really try to see the whole scope of the person and what is troubling them, everything from housing to, children's issues, divorce, family, employment, criminal records, driver's license, everything in the universe you can bring up at that clinic. And the attorneys will meet with you and will give you limited advice and put together an action plan. And that action plan would be the marching orders for how to tackle all of these issues. So some of that will be tackled by saying, come to one of our other programs that VLJ has. For example, the Consumer Law Clinic, right? If the veteran is getting harassed by creditors, you can come to the Consumer Law Clinic. We'll give you all the details about when that happens, who to contact. If an issue is something that we don't handle, what we do is we have all of the referrals. We have lists of other organizations, their names, their numbers. We will set you up with them and give you all of the information that you need to tackle that issue if it's not something we handle. And the other type of representation we provide is also full representation sometimes, which essentially means that we will, synthesize your case. We will type up something for a case list and pitch it to our volunteer attorneys. We have a network of thousands of volunteer attorneys. So we are a small organization. We have, maybe 10 or 12 in-house attorneys. But the network of volunteer attorneys and other law firms and, solo practitioners, they may pick up that case and say, this is something I'm interested in doing. So that's another type of help that we offer. So this wellness clinic is a walk-in clinic. You don't have to make an appointment. Okay, so as I mentioned, I think we talked about all of the goals of the clinic. So we can actually go to the next one, Andrew. Thank you. So the upcoming dates are May 24, July 26th and August 23rd. We hold one once a month. It's usually on a Thursday, and you can just come in. We start at 9 a.m. We advise that you come as early as possible, around 9 a.m., because it's a first come, first serve, and we only have space until 12, so we do have to wrap up. It's held at the East Orange VA Hospital, like I mentioned, and you're probably going to meet with attorneys for about 45 minutes. And depending on how many clients we have there, you would budget enough time to stay there until 12 p.m. There's also valet parking, so that makes it really easy. Okay, now I'm going to talk about the second of our veterans clinics. So this is often a second step for a lot of our veteran clients that come to wellness. So this clinic really, it's also for veterans only. It's also no cost. This one is by appointment only, and this is for clients who have issues with criminal records that they want expunged, with driver's licenses that they need to have restored, and with child support orders in New Jersey that need to be modified. Those are the only 3 types of matters that we give advice on at this clinic. So that's why this is by appointment only. You would contact our office and get all of your documentation in order beforehand so that it's ready to be handed to the volunteer attorneys at that clinic. For expungement, this clinic is essentially a consultation to confirm that you're eligible for an expungement, and then the next step would be that you would be placed with a volunteer attorney who would fully represent you and draft your petition outside of the clinic. So that would be one-on-one representation. So just to give you an overview of the criminal record expungement law, can go one ahead, Andrew, please. Thank you. So a person who is eligible for an expungement is somebody who has a limited amount of convictions and is now leading a law-abiding life. There cannot be any pending matters against the person. We cannot expunge any federal convictions, and we don't deal with out-of-state convictions either. We only deal with New Jersey convictions. But if we are doing an expungement in New Jersey, we do have to know about any out-of-state convictions because they do get counted when we do the determination for eligibility. So even though we cannot expunge them, they do count when you're determining if somebody's eligible. New York, just to let you know, doesn't have an expungement statute, so any convictions in New York cannot be expunged at the moment. Okay, so we can move ahead. A few clicks ahead, I think, to the next slide. So there are 3 main questions that we ask. We're looking at what types of convictions. Are any of them barred offenses, right? Because there's a list of offenses that can never be expunged. For example, robbery, sex offenses, perjury. You can never get those things off the record. Then we're looking at how many convictions, and then we're looking at has the waiting period elapsed. So, types of convictions, they're either felonies or misdemeanors. Felonies in New Jersey are called indictable offenses, and misdemeanors are called disorderly persons. Usually, the indictable offenses are punishable by 6 months of jail time or more, and the DPs, as we call them, are punishable by less than 6 months of jail time. And you can see they're heard in different courts as well, so there's different ways to tell what you're dealing with. The next slide shows barred offenses. It's not a complete list, but it's some of the main highlights of what cannot be expunged. And then if we go to the next slide, I'll just tell you a brief overview without getting into too much detail. If you're trying to expunge an indictable offense, the big crime, the felonies, you can only expunge 1 conviction. You can't have more than 1. Now, you also cannot have any diversionary dismissals prior to that. So diversionary dismissals are when you get a break and instead of, getting sent to jail, you get put in a program to basically avoid that jail time and that criminal record. So currently, under the current law, they see that as you already got a break. If you have what they call a pretrial intervention, a PTI dismissal, or any other kind of diversionary dismissal for a lesser offense, you don't get to expunge anything else. However, starting in October, a new law is going into effect that's saying that that is no longer an automatic bar, which is great news. So people who've had some kind of diversionary dismissal before can still get a conviction expunged starting in October. Okay. So now if we're talking about the smaller crimes, convictions for disorderly persons, you can have no more than 3 that you expunge. And if you're looking at a combination of indictable offenses and disorderly persons, so felonies and misdemeanors, you can have 1 felony and up to 2 disorderly persons. That's the combination. Okay. Now, we can fast forward all the way to the next slide, Andrew. So there's also a waiting period, right? For the indictable offenses, the big crimes, the felonies, there's a 10-year waiting period at the moment. Starting in October, it's going to go down to 6 years. So that's great. And there is also an early pathway exception. So if you can show that in the public interest, it would be good to have this expunged, you could get that shortened to 5 years. For disorderly persons, it's a 5-year waiting period at the moment, and 3 years if you can prove it's in the public interest to get it expunged earlier. Now, that waiting period, it's really important, doesn't start running from the date that you get convicted or arrested. It actually starts running from the last of 3 things to happen, and that is either your release from jail, your completion of probation, or the payment of the fine. So, let's say that you were convicted, you served your jail time, and you had a fine of, I don't know, $500, and you paid $400 of it, and you let the time go by, and you thought you were getting closer to expungement. Because there's that $100 remaining balance, that waiting period actually has not started ticking. So, you really have to complete all of that, and then they start counting that waiting period. Okay? Now, starting in October, they're also being a little more lenient. They're saying if you've substantially completed the payment of the fine, then you would be eligible. So that is good news. Okay, the next thing we do, just very briefly, child support modifications. I'm not going to get into it too much because our next speaker is going to talk more. She's the expert on child support. But so for what we do modifications of orders in New Jersey only. And in order to qualify for modification, you have to show that you have changed circumstances since the time that that order was put in place. And those changes have to be permanent, substantial, and unanticipated. Most importantly, permanent and substantial. So that means that if you just lost your job and you're saying, I need my child support decreased because I lost my job a month ago, the court is going to say, no, that's too recent. We really need to wait a little bit longer to show that that's a permanent change, right? So things like, you know, if you can show a disability that's come into place since the child support order was put in place, or a permanent injury, something that would keep you out of work, or you can show that you haven't been able to find work for a significant amount of time. That would be a relevant circumstance. Or if you can show changes in childcare costs, for example, you have more children now than you did when this child support order was put in place, or health insurance costs have increased for the child, or you are spending more time with the child, changes in parenting time, that would be another reason. So we have to determine whether it is that you're looking for a decrease or an increase in the child support order. We have to determine that these things exist before we can assist you with this. But just wanted to give you all an overview of the services we offer, and you know, thank you so much. Please spread the word about Volunteer Lawyers for Justice and about what we do. And we also have flyers here. Maybe Andrew might have flyers to pass out from us. And please don't hesitate to reach out to me or to our office if there's anything we can do. Thank you.
Thank you very much, Ms. Neal.
I just would like to add something with regard to expungements. If a person has been arrested and they were actually charged, but the charges were dismissed, or if they went to court and was found not guilty, they can immediately request an expungement. But it's on that person to have their attorney to make the request. So you don't have to follow all those rules. Also, if a person is a member of the drug court program, last year, 2016, was the first year that people who participate in the drug court program, there was a special law regarding expungements that state if they meet certain qualifications, like if they don't have a violent history, they don't have a robbery or aggravated assault as part of their record, upon graduation or soon thereafter, they can have their entire record expunged. People who are participants in the drug court program, they are made aware of that as soon as they become a part of the program, and their attorneys represent them regarding that expungement process. So sometimes there are veterans who are participants in the drug court program, and that would apply to them as well. And if they are participants in the drug court program, they do not have to pay any of the fees that's relegated to expungement. Their attorneys will handle that for them, because usually they're government attorneys that's representing them for that process. So afterwards, if there are any questions, I could also answer those for you.
Thank you, Ms. Williams, for help for that additional comments. Also, the Minority Concerns Committee has an expungement seminar, usually once a year. That if you're give us your contact information, we can send you the announcement for that. So thank you, Ms. Neal. And the Volunteer Lawyers for Justice has been very involved with us and getting the word out to the community. And they do provide, they are volunteers, and they provide a wealth of advice, legal advice, for people who need it. Our next speaker is Michelle Richards, and she is the Assistant Finance Division Manager, and with the Superior Court Family Division and Child Support and Chancery. She has been with the judiciary for over 5 years. Prior to her work with the courts, she was with a major accounting firm and an entertainment company as an auditor and financial specialist. She oversees the court-held funds for Essex. This is money that's collected for child support, bail, restitution, and court filing fees. Ms. Richards, thank you for coming, and looking forward to your presentation.
Thank you.
You also have PowerPoint. Okay.
Yes. Good morning, everyone. How are you? Okay. I just want to apologize. I do have some allergies, so I might cough a little bit. I'm sorry. I'm here. Rosa talked a little bit about child support and helped me lead into it. I actually work for the finance division. I don't work for family, but again, because I'm in charge of the court-held funds for Essex County, I deal with all the different areas. So I deal with civil, I deal with criminal, I deal with the family division. So I know a little bit about everything, I guess you could say. First line. Okay, so the purpose of child support. I'm sure most people, whether you have kids, you don't have kids, you know someone who might be on child support, or you've paid child support in the past. The purpose of child support is to make sure that the children, they get the financial support that they need, as well as the non-financial support. So it's not always just about the money. Also, when it comes to child support, you work closely with the family courts. So they help you with establishing legal paternity. The custody and visitation rights, making sure that, and I'll be using these two terms. So the custodial parent, which is the person who's receiving the child support and has the main custody of the child. And then you have the non-custodial parent, who is the payer of the child support. And that's not all the times the father, but 80% of the cases, usually it is the father. So I'll be using CP and NCP. And the other one is to provide access and assistance. Sometimes, families might need therapy. The child might need individual therapy. That's something else that the child support can assist with. And then there's parent education classes. And with parent education classes, that's usually mandatory, especially in matrimonial cases where the parents are married, but also in FD cases where the parents are not married, but there was a child out of that relationship. And basically that's just, the class is usually $25. Sometimes it's free depending on the circumstances. And that's just for the parties to know, how to, have a healthy relationship with their child and, provide support, etc. So applying for child support, usually the custodial parent, so whoever again has main custody of the child, they will apply for child support. And when they do that, it's actually a one-time $6 fee. However, there are some instances where that fee is waived. And that can be waived if they're on public assistance and or if it's like a DV case or there's a restraining order against the non-custodial parent. And then with that, where you can go and get the application, you can go to your local county probation office, your local welfare office. You can go online, and then also a phone number. And I have all this information that I'll make sure I give to everyone at the end. So with this one-time fee, what it includes is the location of the non-custodial parent, because not all the times the custodial parent knows where sometimes the father is. So they have to, locate them. And then also establish paternity. Sometimes you think you know who the father is, but let's say if that person is saying that I am not that child's father, there is genetic testing that does occur as well. Medical support establishment. So again, sometimes the CP might be asking that the NCP, let's say if they're gainfully employed, that, medical insurance should be covered under, the child should be covered under that NCP. And then enforcement of the order. So once an order has been established by the family court of what should be paid, if the person fails to, the NCP is failing to abide by that, or even also sometimes the CP, there could be some enforcement that occurs, and that's usually done by the probation child support enforcement unit. Next slide. Paternity establishment. So again, talking about paternity, usually if both the parents were married when the child was born, the husband is generally the legal father and is noted on the birth certificate. So paternity is usually never, there's no genetic test that needs to be done for that. However, if the parents were not married, legal paternity must be established. So it can be done two ways. The first way could be voluntary acknowledgement, where the person is saying, yes, I am the father of this child, and they'll sign a certificate of parentage, which is like a COP. The other thing they could do is genetic testing. So if they're denying and they're like saying, no, I'm not the, the child's father, the court can then order that a genetic test be done. So you need all three parties. You need the child and both the parents. And if it's 95% or higher, the test results, that person is presumed to be the father. Okay. So child support payments. The child support payment is determined by the family courts. And so they look at a multitude of things. They look at the NCP's, their job history, how much they're making, how much the custodial parent is making, whether they're getting welfare or assistance, if they're, maybe remarried. I mean, there's a lot of different entities that go into it. So once that's determined, the NCP can make payments in several ways. So they can actually have it automatically be deducted from their income withholding. So that means their employer is notified that they have child support, and the employer automatically, however that NCP gets paid, will be deducted from their bank account. So deducted from their check. So it's not one of those things they have to come and pay. It's automatically taken out. And the custodial parent usually gets that money either through automatic deposit into their account and or like a debit card. And then also they can pay, some people who don't have like regular jobs or accounts, or maybe they, the NCP, let's say, is self-employed, they can pay other ways. So you can pay online with a debit or credit card using the payment center. You can pay by phone with a credit card. And again, I'm going to give you these numbers and websites. You also can pay by mail with a check or money order to the payment center. You can also pay in cash only in the child support probation offices, your local county. So for Essex County, we have 3 locations. The first one is 50 West Market Street, and that's at our cashier window. You can make child support payments, and again, cash only. Check or money order is automatically sent to the payment center. So we said if you want it done faster, we say if you're sending check or money, send it directly to the payment center. And the other location is 212 Washington Street in Newark, and that one is that's our main child support location. And you can make child support payments there, as well as 50 Evergreen Place, and that's also done, that's in East Orange, and the hours are 8:30 to 4:30. You can make those cash-only payments. And again, that's just for Essex County. Other counties, they still have the 8:30 to 4:30 hours. However, the locations, it all depends on that county. And then also you can also make payments at specific retailers. So for instance, you have, recently they came out like Walmart, 7-Eleven, Family Dollar, as well as CVS. You can actually, there's payment kiosks where you, for a small fee, you can pay your child support payment there. And then I have all these handouts. This handout will actually tell you about the payments, and that'll be out in the back, so you can kind of get that, or we'll pass it out to you. Next one. Child support enforcement. So if the NCP actually fails to make a payment on time, and I believe it's up to 3 months if they're behind, and then also if they're not maintaining the medical coverage, if that's under the order, then it may be necessary for enforcement to occur, and that's where the probation child support enforcement unit will get involved. And so what happens is some of the things that could occur is that you can have a tax refund intercept. So you're expecting like $1,000 to come back. They might take the whole thing because you're in arrears, let's say $3,000. And they have that right. Because again, this is technically a court order, and it's actually like a debt that you are paying. But again, you have to remember this is also for your child. There also could be a court hearing, so the judge might, order a bench warrant. There's reporting to credit agencies, so saying like if you're trying to buy a car, buy a house, they might see this red mark on your credit report. There could be a licensure denial, so your license could be suspended, and that could be driver's, professional, or recreational. Passport denial, so if you're trying to renew your passport, it might be denied based on your arrearage and not non-compliance to child support. And then seizure of assets. You actually can have bank accounts, property, and everything else confiscated. Okay, and we're coming to the end. So termination and emancipation of child support. So termination can happen for these 4 ways. So again, the child becomes married, child enters the military service, child passes away, or child turns 19 years old. These are some of the immediate emancipation could happen or occur, or termination of the child support. Next one. However, child support can continue past the age of 19 for the following reasons. And that could be that the child's a full-time student still in high school, vocational school, or secondary program. The child is in college, graduate school, or any other post-secondary program. Child is disabled, or it is ordered by the court. And usually the CP is the one that's asking for a motion of continuance of child support, and that can only go until 23. So the child support program is only monitoring and involved up until the child is 23 years old. However, that does not mean that assistance might not still be needed for that child. So again, if that child is disabled, that parent might then now file in family or chancery or surrogate court saying that that child needs assistance. So again, you could be retired and still be providing child support for your child. In Social Security, they garnish those wages for any welfare assistance. Child support will take that, but also when you, if you're now outside of the court and that kid is now 23 plus, and you have to make payments, that's still another legal process. And the last slide, this is just some contact information, so if you have any questions, so this is the number and the website, and then also this is where our main office is in Essex. And then also I have a bunch of pamphlets again in the back. So if you have any questions, just please let us know, and we're here to help.
Okay, thank you, Ms. Richards. Just a brief aside, I did mention that the event is being recorded and broadcast. It's on channel 34, the Montclair Municipal YouTube station, so we can send out the link so people can watch it later. Our next speaker is Bruce Humphreys, and Bruce has been a trial attorney practicing in many different areas of law for more than 30 years. For the past 15 years, he has worked as a hearing officer in the Landlord-Tenant Court in Newark. He's a graduate of Boston University and Seton Hall Law School. He is a frequent presenter for Superior Court on various topics, including landlord-tenant law and civil law in New Jersey. He is also an instructor for the court in mediation techniques and practices. He has authored numerous articles on landlord-tenant law and civil law. He was born in East Orange, New Jersey, and is a lifetime member of the Board of Directors of the ARC of New Jersey, as well as related charitable and philanthropic organizations that assist persons with intellectual and developmental disabilities. Please welcome Bruce Humphreys.
Is it still morning? Good morning, everyone. How's everyone doing today? So, landlord-tenant court is a strange animal. Landlord-tenant court is very different from most other courts in New Jersey. We deal only with one issue down in landlord-tenant court. Who gets the property? Does it remain with the landlord, or does it go to the tenant? So there's very limited issues. It's also a court which is designed to move, at least as far as courts go, very swiftly, very quickly. So how many people here are interested in landlord issues? Show of hands. So we got 4 or 5. How about tenant issues? How many people are here interested in what rights of tenants? Okay. So if you're a landlord, there's a distinction in the law between two types of residential properties. If you have a 2 or 3 family owner occupied, you have one set of laws. And then you have everyone else. So if you're a 2 or 3 family owner occupied, the law was set up to be more friendly toward landlords. If you live there, maybe you as the landlord should have more rights regarding your tenant. If it's everyone else, you have the standard set of laws. So when you're deciding whether to rent out your property, if you're living there, you recognize you might have more rights. If you're a tenant and you're about to move into a place, you might want to consider whether 2 or 3 family occupied, where the landlord has more rights, is appropriate. If you're a tenant and you're renting property in New Jersey, there's only a limited number of reasons why you could be evicted. The biggest one is you haven't paid the rent. That's about 90–95% of the cases that we see down in landlord-tenant court. And let's for a moment assume you're the landlord. If your tenant's not paying the rent, you can file a lawsuit. That's done down at 50 West Market Street. You'll get a trial date about a month later. The court will notify you. The court will take care of notifying the tenant, and you'll come to court on your trial date. The tenant will be there. Hopefully you can mediate a resolution. Maybe that means the tenant will pay the money, or if there's a dispute as to the money, you folks can come to an agreement. If it doesn't work out, you'll see a judge that day and get a decision that day. Now, landlord-tenant court in Essex County is the busiest court, I think, in New Jersey. We do 40,000 cases a year, give or take. That means we have a huge volume of cases. But it's okay, because the judges are used to dealing with a large number of cases. If you're the landlord and if you're successful on the trial date, the eviction will probably be 2 to 3 weeks later, and there's a court officer that the court has who'll go down there, post the notice, and then perform the eviction. If you're a tenant and you were in court and the judge ruled for the landlord, or if for some reason you missed your court date, you can always come to court at the end and try and stop the eviction. You can either try and delay it, or you can try and stop it and get a new day in court, a new trial date, new hearing date. And one of the things that I do as a hearing officer is hear people's requests at the very end. Usually as the officers, they're locking the door, people come to court saying, no, that's not right, I want my day in court, or no, I need a little more time to move. And those are things that we'll consider. Now, I'm happy to answer, after we're done here, some individual questions. But this is a veterans group, and it's, at least it's oriented that way. And I'd like to talk a little bit about, strangely enough, not what happens in New Jersey, not what happens in Essex County, but what's happening across the country. The president, one president ago, instituted a program. If you read the newspapers, and if you believe them, the program was instituted because his wife was pestering him, saying that we need to help our vets. And he then appointed a panel, and they went through the whole big deal. And the program that was set up said that if you're a vet and you're needing assistance for housing benefits, it will be there in almost every case. So that, starting at the presidential level, has filtered down to Newark, New Jersey. And frankly, it's made my life rather easy. If I have a veteran sitting in front of me with housing issues as a tenant, I can look at them and say, you know, we're going to stop this eviction right here and now, and we're going to schedule a new trial date, because the landlord's probably complaining about the rent, and rent should not be an issue in this matter. There will be help out there if you ask the right people. That type of program, at least in those cases, makes my job quite a bit easier. So one of the things is, if you're a vet, and actually with any of the programs that we've talked about today, identify yourself. There might be assistance out there, like I was just mentioning in landlord-tenant court. I had a gentleman sitting about, it was this week, and I was hearing his case, and at the end of the hearing I made a decision which I don't think he was probably too happy with. And then he said something else and something else, and then he said something about having served. And I said, wait a minute, you're a veteran? He said, yeah. I said, take away everything I just said. I'm reversing myself. And I stopped the eviction and scheduled a new hearing, because I know he's going to get help. And for the landlords, if you've rented to a veteran and the veteran is having some problems with the rent, there will be help out there. You have your tenant look for some assistance. Landlord-tenant court is very specific. It's a statutory court. The rules are very technical. But in general, it's also a court that's friendly for people without attorneys. And if you have any questions, you can always go to, someone mentioned it earlier, but we have an information center at the courthouse. It's 50 West Market Street. It's got a fancy name. They call it the Ombudsman. I think Information Center would be a better name, but nobody asked me. And you can walk in there, and they will be able to provide you with some brochures and information on each one of the areas that we touched on today, the various aspects of the court system. They also have some experienced people there who can answer some of your questions. So I'll be happy to talk more about this if anyone has any questions at the end. And thank you for listening and coming today.
Thank you, Mr. Humphreys. That's certainly a large number of cases, 40,000.
I copied it down from.
Great, yeah, perfect.
Thank you very much.
Our next speaker is Erica Spann, and she is the Assistant Criminal Division Manager for Pretrial Services, probably the newest division, and Ms. Spann will explain some more about why that is, but she'll speak about criminal justice reform and pretrial services. Criminal justice reform has been a major initiative of the courts in New Jersey, and I'll leave it to Ms. Spann to explain why that is.
Thank you, Andrew. Good morning. And at the risk of being redundant, but just to understand the importance of, I certainly want to also extend a thank you to those veterans that are here today that did not find it robbery to go and fight on our behalf when we were not able to do so. We want to say that we appreciate you for all of that, and we will continue to appreciate you for what you have done and the way that you've paid for those of us still to come. We want to say thank you. So I just want to talk briefly about criminal justice reform and and as a result, pretrial services, which is the division that I manage here in Essex County. Criminal justice reform began by way of conversations that were being had. One of the things that they talked about was the existing bail system is not fair to poor defendants who, because they cannot post bail, are cut off from families and may lose their jobs. In terms of the charges against them, studies have shown that they face tougher plea offers and pressure to plead guilty because of the amount of time they have already spent in jail. And they receive longer sentences as compared to similarly situated defendants who are able to make bail. Now that was statistically proven. That was something that our Chief Justice, Stuart Rabner, spoke about, as well as our administrative director of the court, who's the Honorable Judge Grant. This is how this began, and they are the force behind it, the steering behind criminal justice reform. And what criminal justice reform, I'm reading just from the pamphlet that's in the back. There are some others there, but this is where I'm taking the information from. It's a definite guideline, walk through what criminal justice is and what it means to the present defendants. So criminal justice reform represents a fundamental change in how defendants and their cases are processed in the New Jersey courts. On January 1st, the state moved from a system that relied principally on setting monetary bail as a condition of release to a risk-based system that is no longer objective and promotes public safety and is fairer to defendants because it is unrelated to their ability to pay bail. So in a nutshell, it's not resource-based anymore, it's risk assessment-based. Okay, it's contingent to the person themselves and their history as it relates to criminal justice. It doesn't matter who you know or how much money you have in the bank. It's really insignificant at this point. The criminal justice system is rooted in two principles: that those accused of a crime are innocent until proven guilty, and that they have the constitutional right to a speedy trial. So when we first had the conversations with regards to how we were going to implement the change, it began with bail reform, because we were just thinking about how someone was going to be released, and it was important for us to know that defendants were not going to be detained because they did not have a financial resource. But when we looked at and we had further conversations and realized it was really going to affect more than just that, because we needed to know that should a defendant be detained, that there was going to be a time frame or a plan for that case, so that defendant in his or her detention would not remain there for unnecessary periods of time. So it changed from bail reform to criminal justice reform, and it laid out a lot of things. It made modifications to the entire criminal justice system, not just bail. The transformation of New Jersey's criminal justice system was a joint effort of all three branches of government that grew from the work of the Joint Committee on Criminal Justice, a special committee of the Supreme Court established by Chief Justice Stuart Rabner to examine the issues of bail and speedy trial reform. And that was the beginning of criminal justice reform. So just to talk about who is eligible for criminal justice, well, everybody, any offense falls under criminal justice reform, but the individual that's affected is a defendant that is arrested and is charged with a warrant complaint. The process now is a little different for that individual. The old criminal world said that the defendant would be arrested, fingerprinted, and could possibly have the ability to pay bail and be released from the arresting agency. New criminal justice world says that defendant is arrested, fingerprinted, and charged and remanded to the correctional facility of the county or city in which they are arrested in order to stand before the judicial system 24 to 48 hours later to determine how that individual would be released if the prosecutorial staff does not deem it or doesn't fall under a statute where a motion for detention will be filed. So that's the way every defendant that is arrested on a criminal complaint warrant has to go through that process now. And the individual is transported to the county jail and, again, subject to criminal justice reform. What happens then is the defendants are interviewed by my staff and the staff of the various pretrial services agencies throughout the state to determine the eligibility for representation, will it be public defender, and then to determine their risk assessment. We perform a public safety assessment for every individual that is arrested on a complaint warrant for the first time. So we complete that assessment, and it's based on a number of things, but it's the risk of a defendant failing to appear, the risk of a defendant being a danger to the community, and the risk of a defendant reoffending. So the PSA uses the defendant's prior criminal and court history to assess the likelihood that this defendant will appear for court or commit another crime. There is a recommendation of no release for certain crimes, those such as murder, most weapons offenses. At this point, it's now grown to defendants that have repeat arrests. There's another one, I'm sorry, it negates me right now, but if it comes back to me, I will. So those particular offenses, if your current charges are those, the recommendation will always be no release recommended, because that's what the statute calls for. But if it is not one of those charges, then the PSA will determine a release decision for you, and we will make that representation to the court. And except that the prosecutorial staff files a motion to detain you, you will be released on that day. Or, depending on the correctional facility you're in, it may be the next morning. Everybody's cycle is a little different. It also depends on what time court starts for us, what time the release decision is made for you. But within 24 hours, you will be released. So, and then you'll be required to comply with certain conditions in order to remain released during the pendency of your criminal case. So you may be required to report to pretrial services. And that's where that's the department where I manage at the Essex County Superior Court at 50 West Market Street, where depending on your level of release, whether it be a level 1, which is the most lenient, with the exception of ROR, but there are no reporting conditions related to if you received an ROR as your release condition, which is release on your own recognizance. So the level 1 is that you would have to report to pretrial service on a monthly basis telephonically, and then it goes level 2, 3, and 3+, and the 3+ is the most, and it will be on a weekly basis, intermittent between telephonic and in-person contacts. And that's what one of the conditions would be. And you would have to comply with that until your case has been either adjudicated by way of plea or trial, or it's administratively dismissed by the courts. But some sort of adjudication needs to happen in order for your interaction with pretrial services to be terminated. Okay, so the first appearance is held, again, within 24 to 48 hours of a defendant being taken into custody. At the hearing, the prosecutor's office must make a motion to have the defendant detained. And certain charges they do, certain charges it does not warrant it. So it does not happen. Otherwise, the judge will set conditions of release considering the pretrial services recommendation and any arguments that are made in the court by counsel, prosecutor, and defense. It's where no motion is made. The judge, after listening to the prosecutor and defense, can agree with the pretrial services recommendation or issue their own recommendation, and they will have to support the same on the record if it's any more stringent than what the recommendation is by pretrial services, or less stringent, it would need to be supported on the record as to why they were deviating from the recommendation, but certainly it is their judicial discretion to do so. Cases where a motion for detention was made, a hearing would need to be held within 3 to 5 business days. And at that hearing, the prosecutor will demonstrate why there are no release conditions that would secure this defendant's appearance in court or safety to the community and that they will not reoffend or commit new charges. Okay, a defendant is released, and a new court date is given for that defendant to appear in court, whether it be at the superior court level or it was remanded back down to the various municipalities. A defendant released with condition they're monitored by pretrial services. Conditions can range from phone calls and visits to the extreme, which would be electronic monitoring with home detention, which is, again, that's one of the ones that we find that we have constant communication with, positive and negative, but we have to communicate more regularly with those defendants that are released on electronic monitoring, because the home detention aspect of it is real, and we know that it could cause a lot of things. So that's a conversation that we talk more readily to, because that electronic monitoring aspect of it is being monitored by people all day, all night. So when they are in non-compliance of it, it does cause a lot of problems. But the ultimate goal of pretrial services is to help those defendants regain compliance and be able to remain out and be successful in the process, have the case adjudicated, and move on in their lives, and try not to reoffend to have to come back to the court. Defendants detained on pretrial are subject to speedy trial guidelines and must meet the various guidelines. The first time frame is a 90-day period where the defendant must be indicted. So the prosecutorial staff must present the case before the grand jury and reach an indictment. If that does not happen in 90 days, the defendant is brought back to court to determine release conditions. They have the opportunity at that point to be released. Okay? If the prosecutors are successful in handing down the indictment within the 90-day period, then a new time frame begins, and it is 180 days that the case needs to be ready for trial. So they're having conversations, between counsel and the court in order to allow this case to continue the criminal justice process. If the trial is not ready for court within the 180-day period, the defendant is brought before the court again in order to determine release conditions. This is all a part of the speedy trial component of criminal justice reform. This is to ensure that defendants are not being detained for unreasonable amounts of time without some sort of just cause. So, and just to speak to those time frames, there are some excludable time periods that can be attributed to this case to extend the 90 days and to extend the 180-day time frames, but there are motions that need to be presented to the court, and they need to be decided on by the judge that has jurisdiction over that case. Okay, so the 90 days and 100 days are that's the primary time, but there are things that could qualify this case and the time frames thereof to be extended. Again, but that needs to be determined by the judge, and the motions by respective counsel need to be presented in a reasonable amount of time so that the adversaries can respond and that the judge can render a informed decision with regards to that defendant. Criminal justice reform, again, it began while the implementation of it began January 1st, 2017, the practice of it began years before that. The work was going in, the conversations were being had, the teams were being created, and the teams began their process in, I want to say, July of 2016. So we've been kind of going at it for a long period of time, and a lot of people have been working very hard day and night in order to make this program successful, as well as making modifications as it relates to the understanding or the implementation of the logarithm that creates the PSA. So there's a lot going on. There's a lot of conversations being had. We're still making modifications even to this day. What we began with on January 1st of 2017 is not necessarily the PSA format that we're working with now. It has been modified by way of legislation and by way of judiciary, how we're looking at certain statutes and how certain statutes are affecting the PSA in order to determine this defendant's release or detention, and ensuring that we are complying with the law and the rules as it relates to criminal justice reform. We are one of, like Andrew said, we are one of the newest units to the criminal justice system, and because we are in our embryonic stage, we are making a lot of changes and a lot of things are happening real time. So if there is anything more that I can lend to your understanding, certainly I would be happy to do so. You can reach out to me at my office. I will be here for some time today after this forum is over in order to lend any type of assistance, because as we know, we govern ourselves by the principle as when we know better, we do better. So certainly we want us to be able to know better so that our community could be better. Thank you so much for your time and patience on this morning, and I'll be here for you. Thank you.
Okay, thank you, Ms. Spann. I'd just like to note that New Jersey has been at the forefront of advancing the criminal justice reform and eliminating bail, and advancing to a risk-based model for supervising people in the community as opposed to maintaining somebody in jail, and it has reduced the number of people in jail tremendously. Because there is an alternative to supervise people in the community. So I just want to mention the Ombudsman's office. We've heard mention the Essex County the Ombudsman is Sarah Hatcher, and the phone number, if anybody would like more information or has any questions, can call 973-776-9300 and extension 56886. So that's the main number, and with the extension, anybody can call the main number if there's other people they need to contact. If you'd like more information, there are postcards you can fill out, and it can be mailed to the ombudsperson's office, or just leave them here, and we'll be glad to pick them up. Or if you just leave your contact information, I'll be contacting you. That's all of our speakers. We'd like to open it up to the audience for any questions. Please make them brief and to the point, and we'll do our best to answer them. Okay, does anybody have any questions? Okay, gentlemen.
Yeah, I have a question. I opened up a checking account, and they went into, the creditors went into my checking account. They went into my checking account and took money out my account, and I had automatic auto pay, and it really messed up with my, the question I'm trying to ask, did they have the right to go into my checking account?
What was it for? Like, who took it? What was it for?
The organization was Pressler and Pressler.
Okay. That was a judge. So that seems like that was like a civil judgment of some sort that was probably filed against you.
Yes, I have a letter here in case you want.
So I sort of can jump in a little bit there. If you have a collection action against you, you can find out all the details by going down to the Ombudsman's office, which is over at 50 West Market Street, or you can go to room 201, customer service, and ask to take a look at your file. If they're actually garnishing seizing bank accounts, that's something you need to look into and get the details, and then there might be some things you can do about that. You have to get the details first. So 201, customer service, all the records, or the Ombudsman's office, and they can check out the details also. So it depends. On the paperwork, it's going to have all these fancy numbers, and one of them is going to be a docket number, and it'll say probably Special Civil Part, SCP, or it's going to say SC, Small Claims, or it's going to say L. But for you, the important part is right before that. It'll have the county with an abbreviation. So Essex County is ES X. I don't even know what Morris County is. I don't.
MRS.
I'm sorry?
MRS.
Yeah. So take a look at the paperwork. Take a look at the docket number. If it has an ESX number, then you want to go down to the Ombudsman or room 201, and at least you can find out what's going on, and from there, perhaps they can give you some advice as to what to do about it. Now, we had somebody up here from the Volunteer Lawyers for Justice, and perhaps they can help. They have a clinic. There's also two other places in Essex County that can help. One of them is Legal Services, and one of them is Legal Aid. Legal Services is at 5 Commerce Street, downtown Newark.
I was just wondering when the Volunteer Lawyers of Justice, they were coming to the Newark One-Stop office. I'm not sure if it was once a month or every other month to do the clinics there. Are you going to do that again? Are you still doing it? Because I had not seen that in a while.
The one-stop office, I'm not sure. Do you know about it, Mark? No. Yeah. Yeah.
Oh, so you don't come to the one-stops anymore?
No, we don't do that anymore. We hold a legal clinic for veterans at the East Orange Hospital. Yeah.
Okay, so I have to refer my veterans to the East Orange?
Yes, please. That would be great. And we have flyers today with the upcoming dates if you want to
Okay,
some up.
because they were still coming knowing that, because we have someone in our office who does the intake for the Volunteer Lawyers of Justice, and she's still doing the intake, so I don't know where she's referring them to.
Okay, I'll give you my card, and I can be in touch with that person, or if they want to call me,
Okay.
we can talk about it.
Okay, great.
Yeah, that would
Thank
be
you.
great. Thank you.
Hi. I don't, I'm loud. I work for HUD, and we attend the veterans stand downs and work with the GI Go Fund. Do any of you all come to those events where there are tons of veterans who may need to ask some preliminary questions about some of the services?
If I get an invite, I will come.
Same here.
Yeah.
Yep, ma'am, we'll speak later, and yeah, we'll find out about those events, and, you know, we'll see if we can send a representative.
We can provide information about housing and on filing fair housing complaints. But it seems like maybe some of you all should definitely be there too, because, you know, while, yes, all vets end up at the VA hospital eventually, a lot of them attend the stand downs, particularly the ones who have and have this down.
Okay, let's speak later about that. Yeah, thank you. Yeah, I just want to maybe recognize some of the service agencies that are here. I know there's a lot of people who are serving veterans. If you'd like to just raise your hand and say if you're with an agency that works with veterans, if you'd like to raise your hand and maybe tell me who you are, ma'am.
Yes, hi, I'm OBrien. I work with JBS in East Orange. We have a program for veterans. We run a very informative men's group on Mondays from 10 to 12, and it's a walk-in and late encounter established a women's group. Our goal is health and wellness, to inform veterans of different things to maintain their conditions and or to not get certain conditions. And I have brochures.
Yes, if they're on the back table, people can look at those.
If anybody would like to have them.
Okay.
Thank you.
So my name is Tina Mikes. I'm with Soldier On. We do serve 9 counties, but Essex County is one. So we are funded by the VA to prevent and end homelessness for veterans and their families. So we provide case management, and we can do financial assistance also. And we're connected with pretty much everybody, like kind of on the panel and in the room. So we also refer out to the appropriate people, Volunteers Lawyers for Justice, the VA, the vet centers, so we all work together pretty well.
Thank you.
I put some brochures back here.
Okay, thank you.
So just as a note, my experiences with your organization, you are most responsive. It's amazing how responsive. Most organizations in Essex County, when you're dealing with county welfare or some of the other nonprofit organizations, you're talking about weeks, sometimes longer than weeks, to see if someone's eligible for help. Soldier On, you don't provide the checks, but you put them in touch with the people who do provide the checks. And I've had people within days or less than days who know they're going to be eligible for help because of the responsiveness of the organization. Okay, didn't know that. By the way, did I get that right about where the program came from? From the top all the way down? Yeah, okay. So, let's start here.
Hi, I'm Kay Dean Bishop, and I work with VA New Jersey Healthcare System. I'm a social worker. I work with Mark, and I'm actually the Intimate Partner Violence Coordinator, and I'm actually here to bring awareness to a new program that the VA has nationally. It's called Strength at Home, and it's really geared toward veterans who are abusing violence in their intimate partner relationships. We have a 12-week closed group. We're really hoping that veterans who are eligible be court-ordered by the courts to participate in this group. I have flyers about it here. My name and contact information is on it. We just completed the first cohort, and we're actually looking to start a new one in group. So all the court-ordered veterans who have DV issues or have issues with anger or at risk of using anger, you know, those are the type of veterans that we're looking to work from particular with the courts. So I'll leave the flyers, and if you have any questions, you could talk to me
Thank
or
you.
Mark.
Yes.
Good afternoon. My name is Denise Harvey, and I'm from the Essex County Public Defender's Office. I'm the life skills advocate there, so I help any defendant, all defendants, but particularly veterans. If they have any services that they're in need of, I look to link them to service providers.
Can I just ask you to speak into the mic
Can you hear me?
a little bit louder?
Okay. Life skills advocate at the Public Defender's Office. So whenever I have a defendant who's also a veteran, I look to link them to any service providers who are specifically geared towards, veteran services.
Thank you.
I'm Brenda Edmondson from the North Cuddy Field Office, and we have DASH, Section 8 vouchers that we issue to veterans, and they're primarily out of Lyons VA Hospital, and there's a transitional program there so that people get the voucher, they go into the transitional program, and then they come out into the community. So that's one way that we help them vets directly.
Thank you.
Hi, my name is Tom Cole. I work for the New Jersey Department of Labor. I'm stationed at the VA Regional Office in Newark in the Chapter 31 VOG Rehab Office, and I work primarily to assist service-connected disabled veterans work through their vocational issues, obtain education benefits, and I work with all of my colleagues around the state in the Labor Department as well as the counseling staff at the VOC Rehab Office to service vets, to help them get past their disabilities and stand up on their own 2 feet and become self-sufficient.
Thank you.
Thank you. Hi, guys. Vince Inataris, veteran, United States Army paratrooper, mental health counselor, work for Northwest Essex Counseling, and have my own private practice also. I work with a lot of veterans, and it's been very informative here. I appreciate that. I want to speak to a few people afterwards. Thank you.
Okay, are there any other questions? Okay, with that, I'll give the contact phone number again for the Ombudsman. It's the main number, 973-776-9300, and extension 56886. And with that, thank you very much for coming today, everybody. And
hello, everyone. My name is Colin Porter. I work with Andrew on the Minority Concerns Committee. I believe we should give him a round of applause because he worked hard for putting this seminar together. And I just want to recognize all the work he put into this. And please fill out those cards. It'll put you on our mailing list. And we have events that's ongoing throughout the year. We actually have an event coming up May 1st. It relates to criminal justice reform and juvenile initiatives. And then we have an immigration seminar, I believe, coming up in August. So please fill out that form and we will keep you informed as we go along. And thank you once again.
okay, thank you, Colin, for your support. Thanks to our speakers.